All right, guys, we're back for another training. Thanks for coming on time. I appreciate it. And today we're continuing our lessons from a legal attorney in real estate who's sharing some guidance and really valuable information to keep mindful of for us realtors. And so we're going to talk about a variety of different discussions and problem areas that are high liability, high risky areas, and hopefully we don't make these mistakes in our own transactions. So if you have any questions, interrupt me at any time. This lesson, this training and time is for you. So feel free to unmute yourself and let's have a discussion on any of these topics. I appreciate you guys' cooperation and wanting and willingness to learn during this time. So I'm Kelvin Chang, your broker. I'd love to share the first comment right now and teach is regarding liability for an owner when you have contractors and subcontractors that are going on a property. This is very common for homeowners to hire a contractor to do property repairs, renovations. Maybe they're adding or upgrading the home, adding square footage, whatnot. So this is what happened, and this is a injury lawsuit that just occurred recently. And this is a discussion where you, the owner, are hiring a contractor to do some work. And if you guys do or do not know, it's very important to talk to your contractor to talk about who is performing the work. Because at this situation, many contractors are general contractors and they don't specialize in a specific area. And so oftentimes a contractor will hire a subcontractor to do miscellaneous work on the property that you hired them for. That subcontractor could be like an electrician, it could be a roofer, it could be a plumber, it could be someone that even does not even have a contractor's license, and they hire a laborer. So what happens if that laborer or that subcontractor gets hurt, or they trip and fall, or maybe the property has potentially dangerous conditions like exposed wires, or maybe they had a cracked roof and a tile slipped and fell from the roof. There's maybe the balcony was loose and they fell over. There's different instances where the property itself would be potentially dangerous. So in this case, there was Qualcomm, a very big tech firm, and they do circuits and different types of technology. They had electrical shorts during their contractor work, and it led to fire and injuries. And guess what? The owners of the property, in this instance, they said in the past, prior to this case, property owners were not held liable for these injuries. But the court made it clear that if the owner was on notice regarding any dangerous conditions, the owner could be held liable. So in this case study, you got to make sure the owner might not be held liable for trip and fall or for some of these instances unless the property itself had unsafe, dangerous conditions. Okay, then the courts might make the owner liable because they should have been given notice or have proper safety measures in place. So that's just something to understand regarding case law. And in this case, you just got to make sure that you talk and have a conversation of who is your contractor. And hopefully in writing, you make sure that the contractor shows to you, their liability insurance that covers them and any employees or laborers that they bring to the property. Very good to put in writing. Okay. The next, any questions on that?
No.
The next topic for we always understand is the transfer disclosure statement. And this is the opportunity for a seller to relieve themselves from any liability, from responsibility on their property when they fully disclose the honest truth regarding the condition regarding any questions like areas that have been painted or improved or areas that are unpermitted. And this is an opportunity to relieve the future liability. So this TDS questions when the seller agent delivers the TDS. And what happens, but what if the seller's agent delivers the TDS prior to the RPA even being signed? Sometimes some agents try to be very proactive, and they do all the disclosures with the owner at the time of signing the listing. And that's good and bad, but what happens is sometimes what they try to do is they try to get the buyers to read and review the TDS prior to, they attach it during the counteroffer period. And so sometimes the buyer may not have any time to reject the contract based on the TDS following the signing of the contract. This was often done in the Bay Area recently. And when you try to, like, for example, the TDS, maybe you make it a condition, buyer to sign this TDS and approve of all the disclosures from the seller when they return their counter offer. And one solution might be to negotiate in your contract when you counter offer them that they still have a due diligence period and they will return it after 5 days of review. So you can negotiate this, but if you see or if you experience a situation where the listing agent is trying to get you to sign off on all these disclosures before even opening escrow, just be knowledgeable that you still can counter them back. You still can negotiate your due diligence period, and you don't always have to follow every term that the seller gives to you. Okay. Another thing that's often in today's day and age is regarding wills and trusts. So let's understand a little bit of a quick difference, okay? A will is a simple, inexpensive, quick way for a property owner to declare on their will who will the possession of and who will be designated in the case of their death. Which individuals will be responsible to acquire the property and gain possession as a beneficiary. When there is no will in place, the property does not necessarily go to the state automatically, but it does go to the rules that are designated by the state of California. So the court has specific rules on what happens when there is no will in place. Generally speaking, the rules say that the property will go to the closest blood relative of the deceased. That could be a parent, their child. Parent and children are first priority. Then it goes to grandchildren and siblings. And then lastly in priority would be cousins, okay? And then et cetera. It can go down the line. So that's the typical rules for California. But a will is not necessarily the best way to protect your property for a person who owns property. The better form to use would be a living trust, okay, or a revocable trust. With this document, it's a little bit more expensive, but it's a lot more appropriate and better for the deceased because they don't have to go through the court rules and procedures. The attorneys and the probate, they'll follow the rules of the living trust, and that will be the document that outlines who are the specific people based on my wishes as the property owner, and who will have control over the distribution of the assets. So if I'm a property owner and I'm deceased, my living trust is in place. I could have my 2 or 3 properties given in different ways. I can have it all to one person. I could have 3 properties being given to my son, Brady, but I could have the decision being made by my wife or by my family member. And those are specific rules that the attorney can put together and help go along my goals for my estate. So I can limit the time and the amount of money given to a specific individual until the certain age is reached. Like I can give the properties to my son Brady, but until he's aged 18 or 21, I would not allow him to access these funds. Okay, so that's something that's cool about a living trust. That's why, as real estate, if you have multiple properties, you probably want to advise your clients to consider putting properties under a living trust, especially if they have health complications or if they have many family members who are, you know, trying to fight for the estate. The last thing you want in real estate, if you're maybe the father head or a figurehead of many properties and you have many family members, when I pass away, the last thing I want is for my relatives to be fighting over my estate. Okay, so I'd rather give my instructions, how my wish to distribute my assets, and you know that would be the instruction that I give, and then not having them to fight is the best. You know, I want them to just appreciate and respect my wishes. Okay, so it's very important, and it's sometimes very often omitted, that you mention any children of the trustor in your will. This includes any adopted children, because adopted children, even though they are not a blood relative, they could contest the instructions of the will or the trust when you forget to omit them or mention them in your estate or your trust. Okay, so that's something to have a discussion with when you have clients who have multiple family members like this or relatives. Any questions? Moving on to the next topic, it's regarding escrow closing statements. How many of you have sold a property and right when you're going into the escrow closing period, the client asked you a question like, what is this fee? I don't understand why they're charging so much. How come they are, you know, charging me $250 for the notary? What is a loan tie-in fee? What is a messenger fee? What is all this junk fees that escrow or the lender is throwing in? Okay. I don't know if it happens to you, but it's happened to me many times where the client is surprised and it has so many questions and you only have one day to review. Okay. So from my experience, I'm going to tell you, whether you're dealing with the seller or the buyer, ask the escrow during the loan doc preparation or loan doc fee time period. That is the time to ask for a estimated closing statement. Okay, that will help you help your clients understand all the costs and expenses that are being charged for the transaction. Most of the times, the escrow officer won't know the lender expenses until the loan docs are prepared. So usually you're not going to be able to get an answer unless the loan officer tells you what their fees are in the beginning or at that time. But otherwise, most clients are surprised to see what are the expenses being charged to them. Sometimes they see, how come I'm paying the extra taxes, and are the prorated taxes and rents calculated properly? So this is to give you the more time to understand everything. Why don't you ask for it right when the loan docs are ready? Okay, that's to help your clients understand what and not get surprised, and they can clarify. They can call their lender to negotiate. They can call the escrow to negotiate and remove some of these junk fees. So if you have a client that is very particular, keen at looking and scrutinizing every expense, then this is what you should definitely do for them. In fact, I do it for every client anyways. Okay, so that way they have enough time to review with their CPA, with their family members, and make sure that their expenses are in line. Okay. Any questions regarding closing statements? The other benefit of reviewing your closing statement is being able to negotiate, which I have been successfully able to do. I don't like to negotiate credits at this time because credits are need to be approved by the lender. And if you're doing it during the loan doc time, you're gonna have to redo loan docs. So you should not, all credits should be already be negotiated and discussed prior to loan docs being approved and by the lender. Okay. But when it comes to junk fees, there's some margin of window like messenger fee or FedEx fee or this and that. You could have and negotiate with those small fees with escrow early on. And but sometimes I also, the advantage of getting this early is I'm able to, I've seen many times errors, and there's been errors where they mislabeled a credit or a debit. There's been errors where they didn't calculate the property county taxes, and they didn't credit the rent situation, or they didn't credit the per diems properly because I'm giving the seller an extra 10 days and they're paying $100 per day. They didn't calculate that amount properly. So why, if you have, you know, interesting situations or transactions that need to be reviewed, get that reviewed up front. We just talked about rent control and eviction moratorium, but the second bullet point here is to understand your property, whether or not you have rent control. Okay. Now remember, every property in California now is under statewide rent control. Every property. But there are separate rules and exclusions that are not automatic, but there are ways for people to get their property excluded from rent control. Okay, so if you are that type and you own a property in California, if you have a single family or a condo or an apartment, basically residential units that are single units, yes, you could exclude yourself from rent control by giving a declaration using the rent cap and just cause form. That's a mandatory disclosure that you do with your rental contracts to add on there and let the tenant understand that your property is excluded from statewide rent control. Okay? But not necessarily all single families and condos are excluded automatically. If you are a corporation, a REIT, or an LLC property owner, then the statewide rent control still applies. You are not excluded because you're a big builder, you're an owner, you're a REIT, you're an LLC, you're a sophisticated investor if you're in a corporation, and therefore you do have statewide rent control, even if it's a single condo or a single family home. Does that make sense? The only way you can still get yourself excluded is if you have, for example, a property that is within 15 years of new construction. Okay, that's one of the ways to exclude yourself from the statewide rent control. And assuming
Kelvin, what you mean 15 years construction within?
Yeah, so if you have a property that was built, let's say you have a property in the middle of city of Los Angeles where there's very strong rent control in place. However, I demolished my old 4-unit building and I converted it to a 6-unit multifamily commercial property, and I have a new construction 2020 or 2010. Maybe I did it 10 years ago. Property could be excluded from rent control because it's new construction within 15 years, depending on your year.
So that means no rent control if we remodeling within the 15
Not remodel,
years?
new construction. So you base it on the county's new construction rules. So if you keep,
New construction, not remodeling.
yeah, if you, let's say you do a big, extensive 99% renovation and you keep the slab foundation and you keep one wall of your property, that's what many people do.
Oh,
Just call that a renovation. But then when you keep that one wall and the slab, that's not new construction. You're gonna get them keep the same 1940 year built. So no, that's not new construction. It has to be defined as new construction by the
I
county.
see, got you. Thank you.
Okay. Now, owners should be made aware of the basics concerning the minimum requirements when you have statewide rent control or minimum laws that are now applied since 2019, the Tenant Protection Act. So this means if you are, for example, a multifamily and I own a triplex, okay, or if I own a commercial apartment building, I do have statewide rent control. All I need to do is I need to understand what are the local and statewide laws that pertain to myself as a landlord. So if I have a triplex and I have a maximum amount that I could raise the rent based upon the property's the previous year's rent plus 5% and the CPI index of the area. Okay, so in LA County, it was somewhere around 7 to 8% was the maximum you could raise for this year in 2020. The other things is I need to be very knowledgeable about the provisions and the length of term that I'm putting in my leases, because once I put a tenant in place, and even if I put them only for a 3-month lease, guess what? They're month to month and they're continuing on. And like this COVID period, we cannot evict them. So you need to understand, length of term, because if you have a tenant that's been there for longer than 1 year, all of a sudden they have much more longer term protections. And not only do you have to give them a 60-day notice to vacate, but if they've been longer there for a year, they get guaranteed rights regarding, each tenant. If you have to evict them for no fault, you even have to pay them money up to maybe, like, for example, 1 month's rent in order to help them with move-in relocation fees. Now, there's also something called vacancy decontrol. And in a specific area, there specific neighborhoods based on geography, when can a landlord put market rates and raise the rates on a huge jump when the tenant voluntarily moved out? And specific areas have vacancy decontrol. So you got to look for this based on your specific city if they have specific vacancy decontrol laws, like City of Los Angeles. Okay. Other cities like West Covina, they might follow the statewide law and they don't have specific decontrol. So therefore, if I had someone who was paying me only $900 a month, and specifically like for West Covina, they don't have a specific law, then yes, I can, my tenant voluntarily left. Now I put it up for the market, I can get market rents. Okay. Now, the relocation allowance that I just talked to you about must give, if you follow statewide rent control, the landlord must give each tenant, when they're giving what's called without any just cause, like for example, they've been perfect resident tenants, they have followed the rules, they did not breach the contract, I got to give 1 month's rent. Okay. The only way I could alleviate or remove myself from that responsibility is I give them a just cause eviction. Just cause means the landlord has valid reason to evict a tenant. And these are typical common examples like they didn't pay the rent, or the tenant voluntarily moved out, or they added so many people to the lease and there's like 5 extra people moved in, or they have pets where they did not notify you, or they have nuisances to the neighborhood or violations against them, and or they're doing criminal activity. So those are all just cause reasons. Okay, so whenever you deal with property management and owners and landlords who try to tell you to do everything, you need the landlord and have evidence that you've sent them information regarding these rent cap just cause new laws. These are statewide rent control things that landlords, half of them don't even know this information. Okay, so
Yeah,
this, you can be a hero and you can save them from making mistakes. Go ahead, Gene.
yeah, Kevin. On the rent cap and just cause addendum,
Yep.
page 2, at the bottom they have something like land. They have a bar and write down landlord here notifies tenant to notify tenant that the property is exempt. If
Yeah.
it is exempt, then will be marked. If no exempt, will be no mark, right?
Yeah. So you can see the page that you're talking about. This is the form that I'm talking to you about, RCJC, just so you can see every rental. When you go to car forms, they won't allow you to not put this form in there. It's a required form, mandatory. And the landlord is supposed to follow and read the civil code section 1947.12 to understand the full language of what the rent control means. And every subdivision, they talk to you that there's a rent cap for the area. Like I told you, LA County was 7.3%, I believe. It was 5% CPI, 5% plus the CPI was 2.3%. Just cause is like I just told you, these are just cause reasons to evict a tenant. They have a breach of the contract. They fail to do, they have a nuisance. They committed waste. They have a lease that was terminated and they refuse to execute another renewal of your lease. Okay, criminal activity, signing or subletting or multiple tenants that are not authorized. Uh, you know, anyway, tenants who refuse the owner to enter the property. That's a reason. So anyways, those are all at fault, and that will be able to alleviate the tenant landlord from giving them that 1 month extra relocation fees. No fault, they have to follow this rules here. And then when you specifically talk about your just cause eviction exemptions, okay, this is where I said there is a certificate of occupancy that has been issued by the city within the past 15 years. Even if that housing is a single family or an apartment building with 30 units, I'm exempted as long as I have a certificate of occupancy that has been issued by the city within the last 15 years. Or I have a duplex and I'm living in one unit, renting out my back unit. But I have to be a owner occupant on one of those units. The third reason is a single family home that's a condo or a PUD, single unit, but I cannot be a corporation, a trust, or an LLC. So if I'm a regular Kelvin Chang individual with my 3 different condos, all 3 separate condos could be excluded as long as I check this box, Gene.
Uh-huh.
To my,
Yes.
okay?
Yeah.
Failure to give this disclosure, failure to let them know and check that box means that now I fall under statewide rent control, even if I'm a single owner individual. So that's why I made it very serious, and I've repeated this disclosure and on multiple times throughout since 2019. Okay.
Yes.
Any other questions regarding this new Tenant Protection Act of 2019? if instead of giving the instructions to the landlords, I always send the articles and tell them to read it, and then I give them the summary. Okay, so I don't ever want to explain all the laws, because if you read the document, it's over 100+ pages long. So
Yeah.
these are the
After I
rules.
read, I forgot.
Yeah. So I don't ever explain it to them, but I tell them summary. You got to fill out this form. Here's a copy of the California Civic Code. If you want to read the summary, there's different articles here, here, and here. But specifically to your question, yes, if you do not check this box, you are subject to statewide rent control, and that's not very good for you as a landlord. So my advice is to check that box if you are a valid owner that are exempted. Okay.
Yeah, and Kevin, I overheard that is it if the tenant pay rent on time, no illegal action. So when we ask them to move out, is it will be paid up to 50K?
Depends on the city again. So if you're in Los Angeles City, yeah, you gotta pay somewhere like somewhere around like
20.
$5,000 to $20,000, depending on how long they've been there and how many people are in there. If you're in another city that does not have any ordinance for rent, then and you have a tenant who has what's called no fault,
Mm-hmm.
then I think it's 1 month. 1 month.
1 month, but do you have any way to prove like suppose how much the landlord have to pay?
Yeah, right here. When there's no fault, the owner has to notify the tenant of the payment of relocation assistance equal to 1 month of the tenant's rent.
Uh-huh. Oh.
In lieu of the payment, the owner may waive the payment of rent for the final month. So I don't have to collect last month, and I can just use that too. So those are your only two options. There's not much to read. This is the summary.
Uh-huh. Okay. So
But this is when there doesn't matter if you have 20 people or 1 people. It's only 1 month rent. It's not as strong as City of Los Angeles.
uh-huh.
Much,
Okay,
much, much more lenient.
yeah, so if we serve the 60 day and they don't want to move, and then we will apply for this compensation to the tenant to move out, or but we have to use the eviction, have the lawyer to do the eviction and then to do this compensation, right?
No, you could do it without a lawyer, as long as you get them to understand and agree, and they mutually accept it. To me, I would not necessarily do it for the final payment of the month. To me, I would rather have their acknowledgement and put something in writing. Okay. Okay.
Okay.
But
Yes,
yes,
thank
if,
you.
if, if they fail to leave, that's when you get an eviction involved, an eviction attorney. This is when you have a dispute, then you get an eviction attorney. If you have no dispute and you can work things out, person to person, and you can cooperate with one another, like I have good relationship with my tenants, I can cooperate with them and talk to them, then I wouldn't need an attorney. Okay, we can have things without it. It's when you have a dispute or a disagreement, then you get the attorney involved.
Okay. Got you. Thank you.
Okay.
Yeah.
All right, going back to the next attorney comments. Any other questions? So I'll bring up the next section. This is very common since a couple of years ago, where ADUs, accessory dwelling units, have been allowed and more lenient by cities and counties, so that we can add housing and more units available for Californians because we had a very strong shortage of supply of housing that has caused and inflated housing values because of the shortage. So the recent law in 2019 allowed additional housing units in the backyards for properties that have a sufficient and meet the guidelines for the local county in regards to ADUs. Now, you could do construction and develop these ADUs as long as your cities approve of your plans and you get the permits in place. But what's common is that certain cities have been very problematic when they do not want to accommodate all of these permit requests. Certain cities would have put together very high fees or take a long time, or they try to delay the ADU building. So certain cities have been what's called difficult to work with, okay? So don't start any work without the permits. Do not do any remodeling of the house or anything like that, because a lot of times, if you need help, CAR has resources available for specific cities that are being problematic or creating high fees or taking too long. Instead of doing the work without the city's permission, I would first advise your homeowner to call the resource at CAR to help them get through the red tape. Okay, so there is a section. I went to the CAR. I'm a director for the state of California, so I have and hear a lot of these important things. Okay, capital gains tax. This is an attorney, a CPA, accountant question, but a lot of times sellers of property are surprised about the capital gains and the amount of tax they have to pay, and everything is circumstantial depending on how they filed their taxes and they report their income. So be sure to always remind your clients to consult with their CPA or accountant prior to the close of escrow, because the way they fill out the escrow tax information sheet and they declare whether or not it's a 1031, they declare if it's their primary residence, they declare if they're exempted from certain specific taxes. That is the time when they fill out the seller's escrow package to consult with their accountant on that page, okay? Do not be the agent that fills this information out for them, because I don't have any idea how they filed or reported their taxes. I don't want to be responsible for checking the wrong box. So if you have a situation like that, tell them in writing, not by phone. Hey, the escrow is waiting for your escrow package to be completed. By the way, you should probably talk to your accountant regarding the property tax information sheet so that you could fill this out properly and take advantage of all of the great capital gains tax laws. For example, if you reported this as your primary residence, you lived here 2 out of the last 5 years, your husband and wife could be excluding up to $500,000 of the capital gains. So that's a great benefit, but check with your accountant on if this is applicable to you if you're married, okay? Stuff like that. So then they can, in writing by email, so you have evidence that you shared this information with them, okay? Any questions on that? Easy peasy, we all know that law, especially if they're doing 1031 exchanges. I always tell them to check with their accountant too, because so many people say, yeah, I use this as a rental property, and yeah, I rented it out for 10 years. And then I asked them, oh, okay, great. But how come your tax return does not reflect this as rental income? Oh, because the tenant pays me directly. I don't report the income. Well, guess what, seller? If you don't report the income, you don't report this as a income property to you. How do you expect to get the benefit the IRS has no idea that you're getting this as a rental income. No, you cannot do 1031 exchange.
Kelvin, we cannot hear you.
Sorry, maybe can you hear me okay now?
The thing is broken up.
Yeah, maybe my internet
Yes.
is breaking down. But I am
Yeah.
ending my training very soon. I have to leave at 3:30 to have a meeting. So I'm gonna finish off this page and then we'll go on. Talking about taxes, when you buy a property, guess what? Or you do a transfer of a specific type of situation, the city or county almost all Sorry, do you hear me better now?
Yeah. It's
Okay.
good right now.
I apologize.
Can you repeat the previous? Yeah, can you repeat a little bit
Yeah.
earlier what you say?
So when I was talking about tax reassessments, the county is always going to reassess your property higher. Almost always it goes higher, unless you fall under a certain exception in regards to property tax reassessment. So certain exceptions, if I do a transfer from parent to child or parent or grandparent to grandchild, that is a valid exception where the city county will not reassess my property taxes. Okay, so that's a great way to exempt reassessment up to $1 million in value. Okay, so this has to be a principal place of residence from the family in order to get this exemption of reassessment. Now, another benefit of tax reassessment exemption is when I'm an elderly person and I'm an individual or a couple and I sell my primary residence and I move to another principal place of residence for equal or less price, whenever I sell my property, I have 2 years to identify my replacement home and take the previous prior tax assessment that I've saved and had a low assessment for many years. I can transfer that base value to my new replacement home as long as I purchase in the same county or a reciprocating county within 2 years. Okay, so that's a great benefit. That's called Prop 60 and Prop 90.
So where are we going to apply for that?
Prop 60 and Prop 90?
Yeah, Kelvin, where to?
When you sell your property, you say you are going to declare and type in, I'm going to use an exercise Prop 60 and 90, and I'm going to talk to my accountant to help me accomplish this goal. That's what you tell the client. Okay? They have to live there 2 of the last 5 years, and they need to check with their CPA.
So is it where to get the form and do this reassessment for the property tax? Like I know it's the 55 years old client, they can do that.
Yes, so when you have a Prop 60 and 90 form, so I go to the LA County Assessor's website, or the title rep in escrow should provide it to you. And Prop 60 and Prop 90, I would send them this link to the client, and I would send them a guide to let them read it. And if you want to get the form, they do have a specific form. I usually just ask the title rep to send the form in the escrow.
But they have to pay some fee ahead. Is it true?
No.
No? Yeah.
So the form looks like this. And then I'm gonna have to end the training because I have another class at 2:30 that I have to attend. So this is your form.
Okay.
You get it from the County of LA website or whatever county you belong to. What's the former property? What's the replacement property? The cost, because it has to be equal or less, or there's a formula if it's above. And then you have
Yeah.
the accountant, because I don't fill this form for my clients. I tell the seller, talk to your accountant to help you accomplish this really great benefit because you had your property purchased in 1991 and you have a very great, attractive property tax basis. Buy something equal or less, transfer this basis over, and your accountant, you pay your accountant, so take advantage of their expertise in getting this accomplished. It's a one-page form. It's very easy. Okay.
Yeah. Yeah. That's the one. Yeah. Okay.
So,
Thank you.
that's it for me. I'm gonna have to sign off. Thank you for being with me for the past hour. Next week, we're gonna continue on our normal clock at 2 o'clock. It's just every fourth Friday when I have to go to budget and finance meetings for the Arcadia board. I have a responsibility I need to meet. Thank you for understanding for this fourth Friday and for the fourth Tuesday, I'm sorry, and of the week. And I'll see you next week or say tomorrow's sales meeting. I'll see you. Okay. Bye, everyone.
Thank you.
Thank
Thank you
you.
very much.
Have a great week.
Bye-bye.
And if you have any questions on, thanks, Adam. If you have any questions on topics you want me to cover for next week, text me or call me. I wanna make this time valuable for you. Okay. See you guys.
Sure.
Yeah.
Thank you. Bye-bye.
Bye bye.